speak to you this evening for Women in Leadership sermon for Evensong at Trinity Chapel. It brings back many warm memories from my 4 years at the sister college, Gillian in the 60s. When I used to come to these services, the Evensong was always my favourite, and I actually sang in the choir. Indeed, as I'm tone deaf, I think it was an indication of the Christian spirit of the chapel, and I was allowed to remain in the choir. Well, I've been asked to speak to you about my own leadership experiences as an international lawyer and the role of faith and spirituality in my own life. Well, some of you may know, I'm an emeritus professor of law, which is Latin, I'm told, for has been. It qualifies me to reflect just a little on my 50-year career in the law. And to begin, I was born in London just after the bombs had been dropped in Nagasaki and Hiroshima at the end of the Second World War. My father was in the British Army and my mother in the Royal Navy, and I grew up in what I think today we'd see as a Paddington Bear kind of world in a London terraced house. I went to the local convent and to the British Museum at weekends. I was a professional ballet dancer at age 11, and with the permission of the Minister for Education, earned the remarkable sum of £5 a week. So how is it that I find myself as President of the Australian Human Rights Commission, and on occasions, far too often, for my taste, on the front pages of some major newspapers? Well, I was clearly never going to make it as a successor to Margot Fontaine or Pleasant Sky. And after my parents moved to Australia, I studied law at this wonderful University of Law School, but was truly dismayed at the prospect of a career in torts, contracts and property law. But I was rescued by and found my life's direction in international law. I read the United Nations Charter and the Universal Declaration on Human Rights, and came to believe even more strongly today, that the rule of law is the fairest and the most sustainable means of achieving world order and peace. To misquote Winston Churchill, the rule of law is an imperfect regime, but better than all the alternatives. Well, life at the University of Melbourne in the early 60s was truly revolutionary. We read Simone de Beauvoir and Jean-Paul Sartre. We talked of existentialism and the philosophers such as Kierkegaard. I was a feminist, as was just about everybody else then, and demanded equal rights. We wanted to make love, not war, and we joined the moratorium marches against the Vietnam conflict. And we thought we had the answers to all the world's problems, and they were fixed. But sadly, the realities of life took over, and we went into the working world. And I continued my legal studies in international law in the United States at Cambridge, and joined the University of Melbourne Law School and an Australian law firm. So as you can see, I've had a fortunate professional life essentially as an international commercial lawyer. I was thus honoured and not a little surprised when I was offered the role of President of the Human Rights Commission, as I was not really a human rights law expert. But Nicola Roxon, Australia's first woman Commonwealth Attorney General, wanted some wider skills. So what have I learned in this position over the last 4 years of my 5-year statutory appointment? A special feature of my job with the Commission is that it's a national one. It should have been, of course, obvious to me when I started the job, but I don't think I really understood quite what a privilege it is to work across the country as a whole. I've been to visit Indigenous communities up the dusty Yellow Road, 3 hours drive west of Katherine. I've visited aged care homes in Tasmania and women's refuges from violence and cairns. I've worked with my counterparts in Malaysia and Indonesia to try to stop the execution of drug dealers, and worked with the business community to employ a more diverse workforce. Sadly, however, I've also visited Christmas Island 3 times and all the immigration detention centres throughout Australia, and I visited juveniles in detention, over 50% of them nationally being Indigenous Australians. I've also learned about the genuine commitment of Australians to a multiculturalism and their belief in a fair go, but I've stumbled upon pockets of profound disadvantage and despair. I've come to understand the power of the media as a force for good, but also as a vehicle for the serious abuse of power. Well, it's at this point that one might ask whether religious faith has helped me in responding to the challenges of my job. Despite nearly 7 years' education in the Catholic convent in London, my father, who had deep religious Christian belief, about unity and diversity in the body. The words, "For we're all baptized by one Spirit to form one body, whether Jews or Gentiles, slave or free. If one part suffers, every part suffers with it. If one part is honoured, every part rejoices with it." These words and these ideals are exactly those of international human rights law, and they underpin all that we try to do at the Australian Human Rights Commission. Human rights apply to each of us without exception and are universal. And that is why so much of the work of the Commission seeks to protect and ensure the rights of the aged, the disabled, those of religious and racial minorities, along with the unity of community purpose. This evening I'd like to focus on some contemporary issues to illustrate a point that I would like to leave you with to think about. That is that respective federal parliaments have failed to protect fundamental human freedoms and rights in Australia, particularly over the last 10 to 15 years, and that our judges and courts have also failed to take up the challenge to overturn those parliamentary statutes that violate common law rights. There are many hundreds of examples, but perhaps we can begin with one, the Northern Territory juvenile detention. The first is then the shocking CCTV footage on Four Corners 2 weeks ago that's unleashed a firestorm of political and legal debate. Incontrovertible evidence of Aboriginal children subject to demeaning, debilitating and dehumanising behaviour has galvanised the Australian community and prompted the creation of a Royal Commission with unprecedented powers of investigation and include consideration of whether the acts violate a core international human rights treaty, the Convention of the Rights of the Child. The Royal Commission into Aboriginal deaths in custody over 25 years ago has long warned against the disproportionate effects of incarceration on Indigenous Australians, all too often leading to their deaths. Sadly, this week we've seen even further evidence of such cruelty in detention centres in Queensland. The second point example I wanted to give concerns the Nauru asylum centres. The evidence of the treatment of Aboriginal youths in the Northern Territory was compounded when we received yet more evidence of the cruel and inhumane treatment of about 50 asylum-seeking children on Nauru. The evidence, while shocking, was not new. There have been repeated inquiries, Senate investigations, United Nations reports, including my own Forgotten Children report, that have attested to the dangerous conditions for children in various forms of detention in Australia and in offshore facilities, over which Australia has effective management and control. The third issue, and again a contemporary one, concerns the inability thus far to resolve the question of equality of the marriage laws, and I'll come back to that point in a moment. But a common feature of each of these issues is the role of Parliament in passing laws that risk our fundamental freedoms. Parliaments of respective governments have enacted provisions of the Migration Act that uniquely mandate the detention of all those who arrive in Australia by sea without a visa. The Act also provides for the removal of unauthorised maritime arrivals to Manus on Nauru for processing their claims to refugee status. The effect of these laws is to consign refugees, and indeed most are subsequently found to be refugees, to years of detention without hope. Sadly, when these laws were challenged before the High Court of Australia in the rather uninterestingly termed M68 case, in a 61-6 judges to 1 majority, it was held that the laws are valid under the Australian Constitution. This decision stands in stark contrast to the unanimous decision of the Papua New Guinea Supreme Court a few weeks later that detention on Manus was a violation of the right to liberty under its more modern constitution. The story is similar in respect of the treatment of juveniles in the Northern Territory detention system. The Northern Territory Parliament has passed laws that allow a so-called 4-hour paperless arrest by police with the express purpose of ensuring that the police do not have to do the paperwork. It is contrary to the fundamental right to be brought before a magistrate as soon as is practicable after arrest. This law was also challenged before the High Court, and again there was a 6-1 majority finding that the laws were valid despite the significant evidence of discriminatory effect on Indigenous Australians. So my question is, why is there no ability to ensure fundamental freedoms and rights are protected in Australia? Why can the Papua New Guinea court reach such a different view of its laws compared with those of Australia? And there are several answers. One is that Australia is the only Commonwealth country in the world that does not have a Charter or Bill of Rights. Secondly, Australia is exceptional in that we have few constitutional protections for human rights. The Constitution protects the right to vote, to the acquisition of property on just terms, to trial for jury, and to due process, and freedom of religion. And all other freedoms depend for protection upon other sources, especially the courts and the law. Critically, while Australia has been a significant contributor to the international human rights treaty regimes, we've ratified these treaties in the international environment on the international stage, but we have not implemented those treaties in Australian domestic law. Well, the lawyers here tonight might say, well, there's always the right or the principle of legality under common law. If the Constitution or a Bill of Rights doesn't protect our rights, our common law we've inherited from the years of the Magna Carta will apply. And you might remember that buried in the Magna Carta is that wonderful phrase, no man may be detained arbitrarily without charge or trial by his peers. But sadly, the principle of legality or the common law protection of rights, though oft repeated by our courts, does not apply in practice. And the reason for that is that where the law is crystal clear, the will of Parliament must be sovereign and must be supreme. And in the areas of law that most concern me from the point of view of human rights, the rights in relation to freedom of detention without trial, to disproportionate counter-terrorism laws, to infringements on the right to freedom of speech, all of these laws are ones which are very unambiguous and clear, so that a court is placed in the awkward position of having to apply the parliamentary provision, despite the fact that there are clear common law principles to the contrary. The result is that in Australia we don't speak the language of international obligations or human rights when discussing public issues. And indeed, when the United Nations rapporteurs and the Human Rights Council raise their concerns about Australia's human rights record, the political response is we will not be lectured to by the United Nations. Indeed, the report, the Forgotten Children's Report, on the condition of children in detention centres as refugees, was presented to Parliament, as I'm required to do, of course, but the head of the relevant committee, the Legal and Constitutional Committee, declared that he was too busy to read our report. Well, my mandate as President is to hold account the government and the private sector for compliance with human rights laws. But as most of the international human rights obligations have not been implemented to form part of domestic law, this creates an insuperable problem and can, on occasion, place the Commission on a collision course with the federal government, particularly, of course, on the asylum seeker questions. Well, I'm often asked how I dealt with the unprecedented criticism, both of the Human Rights Commission last year and of my own professional competence and objectivity. I recently saw a new play, I hope it comes to Melbourne, called The Hansard Monologues, and what it did was to reenact part of the 8 hours of Senate questioning of me last year. And it was, in some ways, more harrowing for me to go through the play than it was to sit through the Senate questioning, which is, after all, part of the democratic process. But to try to answer the question, I think I'm certain in preparing that report, visiting all the detention centres, some of them several times, speaking directly to over 2,000 asylum seekers and their children, holding 5 public hearings under oath, and receiving submissions and expert medical advice, I believe that the report was accurate, fair, and measured. In short, the law that I learned at this university was my best friend, because I knew that I'd done my homework, my colleagues had, and we'd made a reasonable and fair judgment of the breaches of human rights law. In dealing with the aftermath of political criticism, I've been able to rely on a certain lesson of resilience, a quality that is especially important in times of challenge. I had the support of my family and friends, but also of the Australian public. I received thousands of emails, cards, letters, phone calls, knitted scarves, lace handkerchiefs, and flowers. Indeed, I received so many flowers that crowded into my office that I thought I must have died the week before. But there's a problem for women in dealing with these situations that is perhaps unique during the questioning and of course other St. estimates and other really very strong criticism of my work. I did think, as I sat facing this questioning, that I had a number of options. One was to be as discourteous and rude in response. Another was to burst into tears, or the other was to faint. Well, I didn't think that any one of these was going to be any good. But also, had I done so, I would have lost my case. If I had given in kind what was being served to me, I would have lost my case. And I think it's especially something that maybe women are alert to. We cannot play the game the same way. We must stand for what we know is the truth. We may be wrong in our estimate of the law, the facts, but if we've done our work, we're almost clear that we've done our best, then I think we must have the resilience to stand up. There's also another problem for women, and that is the victim card. If we were to complain, then we're seen as being a victim. Now, women, of course, are on occasion victims, but I have learned in my own nearly 50-year professional career that it's not a good card to play. It actually does take away from the strength of the card of the case that you're attempting to argue. So I've found, as I say, the law has been my best friend because by getting the evidence right, doing my homework, getting the law right, I've had the confidence to stand up for what I believe has been right, even though I might ultimately be proved to be wrong. Well, to conclude, what lessons have I learned that might be useful to a young student, perhaps especially a young woman of today? Well, one thing I have learned is that comedy is a very effective antidote to bad laws. You might remember the baby Farou's case. He was born in Brisbane and a mother had arrived in Australia by boat without a visa. And under the Migration Act, there's a legal fiction. Lawyers are used to this, but to anybody else it seems utterly irrational. But there's a fiction that the baby is deemed to have entered Australia by sea and cannot apply for a visa. I spent some time on this island trying to explain in the heat to the mother of baby Farous, who was of course in tears, that the legal fiction was that although she was with her baby when he was born in Brisbane, the baby was deemed to have come illegally by sea. Well, I made little headway in attempting to help baby Farous' mother, but a week or so later I was back in Australia and I saw Sean McCaleb's TV program, Mad as Hell. And in it he had a picture of baby Farous and said, "How dare baby Farous hide in his mother's womb for 9 months prior to jump the queue in Brisbane." Well, he achieved more in 30 seconds than I could ever have achieved, but it certainly teaches me the lesson that the deeper points that one might want to make as a human rights lawyer can be achieved in much more subtle ways. I've also learned how difficult it is to apply the rule of law in practice. Reasonable minds in good faith do not always agree on the limits to freedom of speech and assembly, and the right not to be detained without trial when balanced against national security, border control, and counter-terrorism. There are no simple answers to finding this balance other than calm assessment of the evidence and the drafting of necessary and proportional laws to address the problems. I have been concerned, as I said to begin, that Parliament and the courts have not been able to stand up for the fundamental freedoms that underpin our multicultural society. And a recent example, as I indicated earlier, is the failure for Parliament to deal with the problem of marriage equality. We now are facing a plebiscite that is compulsory for the public but not binding on Parliament. It will be expensive, it will possibly be very divisive, but it's a reflection of the failure of Parliament to come to grips with the question of what is equality before the law, and indeed to vote on this very vital question of leadership. And that leads me then to my final point, that I have learned in this job the importance of leadership and the principles that underpin good governance. With wise leadership in the interests of all Australians, we can rise to be the best that we possibly can be. But without that leadership, we risk betraying the values of equality and justice that underpin